So, the big one, number one, the SPCA Act provides police powers to its investigators. It's at Section 11 of the Act. And for those of you, most of you probably know this already, but the OSPCA is a private organization. They are the only private organization in the province of Ontario, certainly at least, that has police powers. And it's fascinating. I mean, I don't mean that in a positive way, obviously, but it's fascinating that this ever came about. The police and the duties of police officers, which are the duties of the Attorney General as well, those are supposed to be within the controls of the government. Because the police have extraordinary powers, of course. And if they step over the line, if they conduct themselves badly, we are supposed to have some recourse. Even our bylaw officers out there, who many of you probably had some bad experiences with, at the very least, they are under the direction of counsel. Now, you may not agree with counsel and their decisions, but at the end of the day, at least they are under the direction of elected officials. But the SPCA are not. They're a private organization, and they're completely autonomous from the government. So you have a situation where you have a private organization given these extraordinary powers, and what's to stop the organization from desiring to forward some of their own agendas, right? What's to stop them from having certain ideologies that they hope that through the enforcement of the law they might be able to achieve? It's a very dangerous situation, certainly. Now, the government, we sort of expect that from them, right? The government is supposed to have, forward certain values, and so when it comes to election time, we look at the candidates, and we look at their values, and we oftentimes will vote in order to reflect whether we agree or not agree with those values. But when you take this component away from the government, there's no control over that. They operate on their own. They operate on revenues that are derived from their own fundraising. So here again, you have an extremely dangerous situation, because not only now you might have a situation where the people involved in the organization may be wanting to forward certain ideologies, but because they are dependent upon donations from the individuals, you now can have individuals, effectively influence how they are going to conduct themselves by way of their donor dollars. Now, we of course know that there are, especially in the animal rights realm, there are some organizations that are extremely well funded. There are organizations from outside the province as well that are extremely well funded. So now you have all of these sort of pressures taking place on how the law may be administered, because you have a private organization with these police powers. Very dangerous situation, in my respectful opinion. In addition to that, in Ontario we have the Police Services Act, and there is an entire portion of that act dedicated to restraining the powers of the police. We have a review board where you can take complaints to. There are regulations under the Act that specifically prohibit various types of conduct and sets out a variety of things, including the use of force, how the police engage in political activities. And these are all safeguards put in place to, there's no guarantee, but to at least improve the possibility that the police may be acting in a way that they shouldn't be acting, essentially, and that instead they are more objective in administering the law. Because the Ospca are not police officers as defined by the Police Services Act, they're not subjected to it. So what it is I find just incredible is you have an organization with all the powers of a police officer and none of the restraints, which by some simple math tells me that they have more powers than the police. It's a shocking situation. Other individuals or organizations that are under the umbrella of the government are subjected to the Ombudsman Act. But they don't qualify for that either. So where do you go with a complaint to the Ospca? Well, you go to the Ospca. And you will have as much clout with that complaint as you would if, let's say, you had a complaint about your Rogers bill or something along those lines, except probably even less power because you're not their customer, right? So there's nothing in place whatsoever to sort of keep us safe from the potential bad conduct of the SPCA. So, Section 11 of the Ospca Act provides police powers to the Ospca. So, as part of our application, we are asking the court for a declaration that that section of the Act infringes upon Section 7 of the Charter. The Section 7 of the Charter is the right to life, liberty, and security of the person. And as part of that, when we do an analysis under Section 7, part of that is that the law must adhere to fundamental principles of justice. So when we go to the court with this question, we'll be asking the court, is it consistent with fundamental principles of justice to have the law enforced by a private organization with no government oversight or accountability? Oversight, I forgot to mention. The SPCA also are not subjected to freedom of information. So when they develop policies, and we know they have them, we have copies of some of them, we can't even know what those policies are. And in addition to that, when the police keep a record on you, provided it's not part of an ongoing investigation, you can get access to that. So if you're being watched by the police, you can find out about it effectively. And again, the SPCA are not subjected to that, so they can be keeping files on people and no one will ever know because they're not subject to the Freedom of Information legislation. Municipalities, once again, are subjected to their own, like they actually have recognized, I think, the need to do that with municipalities because they have their own Freedom of Information legislation, which gives you access to documents that the municipalities have, although it can be quite a challenge, nevertheless, as Don has experienced. But in any event, at least it's there, right? In theory. So, no accountability or oversight. The second of the four is the definition of distress. Now, when somebody is charged with breaking the law, there are so many laws out there, right? And it really is ludicrous for anybody to be expected to know all of them because there are just so many. But there is a principle that we've all accepted as part of society, that ignorance is no defense, which means you can't say, well, I didn't know it was against the law. If it is against the law and you've done it, then effectively you can be convicted of that. Now, what's the flip side of that? The flip side of that is, if there is a law out there, it needs to be understandable, right? If you're expected to know it, then it has to be understandable, so that if you were to actually read it, you could know that you were breaking the law. And that's why there is countless cases where laws have been challenged on constitutional grounds for being overly vague. In other words, you can't have a law that says, such and such against the law if the wording is so vague you're not, even after reading it, you're not sure what's against the law. And I'll use an example for you. There's a lot of federal obscenity laws that have been struck down on these grounds because they'll say things like, you can't have offensive materials. Well, they've struck these types of laws down for not being precise enough. We still have them, but they had to get more precise to say exactly what they're talking about and what they mean by offensive, because what's offensive to one person isn't going to necessarily be offensive to another person, right? And we'll be introducing similar arguments when it comes to distress, because under the Uspca Act, distress includes undue hardship. And it's funny, I'll just add to it as well. Oftentimes, when a definition is provided for a word, it is done so that it becomes more precise, right? So that we can better understand what that word is supposed to mean. But the Uspca Act has done the opposite, because they've got, there's probably a dozen words in the definition of distress that, when I read distress, I get a pretty strong intuitive feeling of what that will involve. But by adding terms such as undue hardship, for me, that broadens it, actually. And that actually contributes to it being more vague. Because what is undue hardship? Is it, one cow has 3 inches of bedding and one cow has 2 inches. So I guess the cow with the 2 inches is experiencing undue hardship because this one's getting 3, right? And that's why we have these cases, too, where tartar on the dog's teeth are being interpreted by an investigator as being distress, whereas most people are like, well, that's hardly distress. Tartar on it, I might have tartar on my teeth, right? I don't feel like I'm in distress. That's why we have, oh boy, geez, 10 minutes already. Time flies. And that's why we have cases where an Amish person is being told to provide toys to their dogs, because it's undue hardship to not have those things. And this word distress is in the legislation throughout. There's charges specifically for causing it. There's charges specifically for permitting it. To get a warrant to go to a person's property, what's required is a reasonable belief of distress. To issue orders, reasonable belief of distress, and so on. It is featured throughout the legislation. And so this causes problems not just from from the standpoint of, well, I don't know if I'm causing distress, so I don't know if I'm contravening the prohibition against causing distress, but it also causes problems for the inspectors, because they're going to import their own subjective interpretation into it there when they're issuing orders. It's going to cause problems when they go to get a warrant, because the justice of the peace is going to import their own subjective interpretation of what's distress as well. And it's just too open for such subjective interpretation. So, number 2, we're asking the court to find that the definition of distress is too vague, and all the portions in the legislation that rely on that word would be declared overly vague and also unconstitutional. The next thing, and I'm going to be very brief on the last 2. There are various sections in the Uspca Act that authorize searches and seizures, and many, if not all of them, are pretty extraordinary, including going into people's homes any time of day without a warrant. That particular provision is attached to the orders provision. So if you end up with an order against you, they can come into your home at any time, and check and see if you're complying with it. There are also the provisions of to seize your animals and so on. And so Section 8 of the Charter protects against unreasonable search and seizure. And so we will be asking the court to look at those and ask the court to make a determination of whether or not these provisions are unreasonable pursuant to Section 8.